Everybody wants freedom. Everybody wants freedom. Freedom of thought. Freedom to talk. Everybody wants freedom. Everybody wants freedom. Freedom of speech. Freedom to teach.
Good evening, viewers and listeners. Welcome to another edition of the program, The Rights of the People, brought to you every second, third, and fourth Friday of the month by the Thusian Institute for Religious Liberty, a non-profit, non-governmental religious liberty institution which provides human rights education services with a special emphasis on religious liberty. I'm your regular host, Mrs. Anissa Batiste. Let us start with a word of prayer. Loving Father in heaven, please help me to speak the truth to the people and nothing but the truth. In Jesus' holy name I pray. Amen. And now, my dear people, in this evening's program, we wish to take a look at defending freedom of expression. But before we do so, let me remind you of how you may contact our institute. You may do so by writing to us at TIRL SVG, that's TIRL SVG, at firstfreedomthink.com. Or you may log on to our website. The address is www.firstfreedomthink.com. You may contact us by telephone numbers 528-1015 or 432-5268. And for those of you who wish to contribute to our program financially, you may deposit your monies at the National Commercial Bank or the Bank of St. Vincent and the Grenadines, account number 129358. That's 129358 as what was known as the NCB. And now, my dear people, in this program, Defending Freedom of Expression, we wish to reflect on what has happened in our society on March 3rd. On March 3rd, Thursday, March 3rd, as you all know, there was an incident in the House of Parliament, outside of the House of Parliament, as a part of the protest that was led by the opposition, and members of Parliament on the opposition side were forcibly removed from the Parliament after they refused to obey the rules of the House by the Speaker, and in being forcibly removed, they were brutalized. The Thusian Institute for Religious Liberty has issued a statement concerning this incident, which I would like to read for you today. The statement is issued by the Secretary General of the Thusian Institute for Religious Liberty, Mrs. Anne-Marie Ballantyne, on behalf of the Institute, and it is entitled, TIRL Strongly Condemns All Brutality. And I'll read it for you. It says, the members of the Thusian Institute for Religious Liberty, Incorporated, a human rights and freedoms education provider with special emphasis on the right to religious liberty, strongly condemns the excessive and brutal force that was meted out to members of the opposition and some protesters by some police officers on Thursday, March 3rd, 2011. The police have a duty to protect and serve all the people without brutality to anyone whatsoever. Members of all political parties must be treated equally with respect for their God-given rights and freedoms. Any violent and intolerant behavior is unacceptable in the eyes of God and by the Constitution of St. Vincent and the Grenadines. We also condemn every open and subtle threat made to the person and property of any protester. Protest is a natural God-given freedom. It is a statement or action to express disapproval of an official policy. The protest held last Thursday in and outside the People's Parliament was a reaction to the passage of the Criminal Procedure Code by the ULP administration and their move to amend a section of the Representation of the People Act. The Criminal Procedure Code now makes it mandatory to seek permission from the Director of Public Prosecution to take a criminal matter to the court. An individual no longer has the choice of lodging a private criminal complaint directly to the court. The amendments to the RPA, or the Representation of the People Act, take away stiff penalties for crimes of slander and libel that are committed by candidates before and during an election period against other candidates. We call on all Vincentians, including the guilty police officers, to respect the rights and freedoms of their fellow men while they exercise their God-ordained freedom to protest. We also call on governments to realize that they are ordained by God to minister good to all the people and not to be a terror to good works, but to the evil, according to Romans chapter 13, verses 1 to 5. Government must serve the citizens by respecting the rights of all the people, regardless of their political affiliation. This is the end of the press release. This information constitutes the position, the official position of the Thusian Institute for Religious Liberty. We are not in any way in support of the brutality that was meted out to protesters and to members of the opposition in the parliament. We believe that protest is a form of freedom of free expression, and it ought to be allowed, it ought to be respected as one of the natural personal freedoms with which God hath endowed all of humanity. And we also believe that the actions meted out to persons represented an extreme and excess, even in carrying out the authority of the House, of the Speaker of the House, and that this ought not to be so. It ought not to be accepted and tolerated that people be brutalized when exercising their natural, constitutionally protected, and more so, God-given freedom of expression, even in the form of protest. And we condemn the brutality that was meted out. We understand that in one case, one member of parliament is nursing injuries to his back and had to fly out to Trinidad to seek medical attention. We condemn such acts on either side, and we're saying that equality before the law and respect for the rights and freedoms of all, regardless of political affiliation, must be maintained, respected, protected, and encouraged. Having said that, we were looking at the issue of protest and the issue of freedom of expression because this is what happened then. And we recognize that throughout the ages, and even today in society and in our world over, we've seen a lot of protests taking place in different countries of the world where persons are utilizing their natural freedom of expression to express or to say how they feel about governments and how they are treating them and how they are governing and operating in their respective countries. St. Vincent and the Grenadines is no exception. The people of this country reserve the right to protest, to exercise their natural freedom of expression in the form of protest, even against governments. And governments ought never to encourage the security forces to turn upon the people to hinder them from so exercising their freedom of expression in the form of protest, and certainly not to brutalize them, because whenever such action is resorted to, it is an attempt to stifle the free expression of the people by seeking to instill fear in them so that they would shut up or not speak out, for fear of being brutalized and violently treated. And this ought not to be so in a society that boasts democratic practices, that boasts freedoms to participate in governance and representation of the people. And so we condemn it strongly, as you have heard from our release. While talking about that, I wish to take a little look, so to speak, down memory lane in making some comparisons of what happened. We are reminded of the period of 1998, when a similar situation existed, where there was an 8-7 situation in the country in terms of the results of the election. And when we look back in previous newspapers from around that time, July 1998, in the Vincentian and Searchlight and other papers, we see reports of a similar protest taking place for different reasons. In this case, it was the New Democratic Party was in government and the Unity Labour Party was in opposition. And there are some comparisons that could be made to show how there's need for equality and equal treatment. And we want to highlight just briefly what we're talking about here. I'm looking at a newspaper piece that was done by Marlon Butte entitled ULP Supporters March Outside Courthouse. And this took place in the period of July 1998. And the story goes like this. I'm reading a portion. It says, pandemonium broke out last Thursday evening as scores of ULP supporters jeered and pelted the vehicles of government ministers, the Honourable Monty Roberts and the Honourable Annie Eustace. The ministers were leaving Parliament after newly appointed Speaker of the House, Nolwenn MacDonald, adjourned it after he had clashes with Leader of the Opposition, the Honourable Vincent Beach. The opposition has taken issue with McDowell's appointment, saying that it is a highly esteemed office and that McDowell was rejected at the polls when he was beaten by Deputy ULP leader, the Honourable Ralph Gonsalves, in the June 15th elections. The ULP nominated parliamentarian Louis Straker, but he failed to get the nod on an 11-9 vote. The arrival of the Governor-General, Sir Charles Antrobus, at the House of Assembly also evoked a strong reaction from the ULP supporters, who loudly booed the head of state, and as the Governor-General entered the House, the opposition left, only to return when he had completed the speech from the throne and declared the first session of the 6th Parliament open. They had earlier refused to stand when the Speaker of the House entered, and all were asked to rise by the Sergeant-at-Arms. McDowell's departure also saw him being surrounded by angry protesters. I pause here for a moment. What I want to highlight is this. In 1998, you had similar protests. People were not satisfied with the way the election went. There was an 8-7 situation. There was an argument that the ULP, who had got 7 seats and who were to remain in opposition, had had the popular vote. And there were people expressing themselves, freedom of expression, and being very angry and protesting. One of the things we note concerning the Parliament is that the government members were there, the opposition members in protesting. They actually walked out when the Governor-General arrived because they were protesting his election, Nolwenn McDowell, because they didn't feel he should be, sorry, not the Governor-General, my mistake, Sir Charles Antrobus, not Nolwenn MacDonald. Sir Charles Antrobus was the Governor-General then, and the opposition at the time, the Unity Labour Party, protested his appointment because they didn't think he should be Governor-General, and what they did in protest is they walked out of Parliament when he arrived. And in another case, what they did too is that when the Speaker of the House entered and all were asked to rise by the Sergeant-at-Arms, they refused to stand. So in protest, they sat down, even though they were asked to stand as a part of the functioning of the House. Now, the comparison I want to make is simply this, my dear people. We did not see, or we don't hear of accounts back then that tell us that for failing to cooperate with the order of the House, we did not hear they were forcibly removed by the Speaker or even brutalized by the police officers. But their decision to remain sitting, even though they were asked to stand in acknowledgement of the Speaker, was their way of protesting, their way of freedom of expression. And what we're saying is that there should be equality. We should be made to see that the same treatment meted out to one side is also meted out to the other side. And sad to say, in 2011, March 3rd, when we had the opposition taking a position where they refused to sit, the opposite now, when the Speaker asked them to sit, they were, not only the order was given by the Speaker to have them forcibly removed, but they were also brutally dealt with by certain police officers, and that is to be condemned. In freedom of expression, there must be equality. One must be free to express him or herself according to their natural freedom, and it must not matter which political party they belong to. I simply wanted to point that out to remind us of what history has shown and to show the difference in treatment that was meted out this time in March 3rd, 2011, which we condemn. Okay, having said that, let us go back a bit briefly to the reasons why the protest was taking place. We here at the Institute supported the idea of protesting because we understood that the protest was being done against two pieces of legislation that were brought before the Parliament by the governing body, the government of the day, the ULP administration. We know now that the Criminal Procedure Code, Section 69 thereof, has in fact been amended. The process has been completed. That is, not only did the bill receive its 3 readings and was debated and so on, but it also has been assented to by the Governor General, Sir Frederick Ballantyne, and as far as we understand, it has been gazetted also. So it is now law. And what the amendment did, and what is now law, is that anybody seeking to initiate criminal complaints in the court must receive a fiat or authorization from the Director of Public Prosecutions, the DPP, in order for them to pursue such a matter. If they don't get a fiat, they cannot lodge a criminal complaint in the court. In addition, the law was retroactive. That is, it points to and it affects allegations of wrong that took place before it became law. So if you had a complaint against someone who you allege did something wrong to you, but that allegation is concerning a wrong that was done, allegedly done, before this bill was passed on March 1st, I believe, you still have to go to the DPP to get a fiat. So matters that may have already been filed, you have to go back to the DPP because the effect of the law makes it retroactive, looking back to a time that is before the bill became law. And that's the reality today. We have said to you that this takes away the right of the people to bring a private criminal complaint before the court without having to go through the DPP. And I just want to refer to a quotation that was used by Miss K. Bacchus Brown, a lawyer here in St. Vincent and the Grenadines, in a response that she wrote to P.R. Campbell's analysis of the Representation of the People Act. In it, she made reference to a particular quotation from the Canadian courts concerning this right to bring private criminal complaints, and I want to highlight it because it shows the implication of the amendment that has been made to our Criminal Procedure Code. She said, and I quote, "The Canadian court describes this private right as follows," and I quote, "The right of a private citizen to lay an information and the right and duty of the Attorney General to supervise criminal prosecutions are both fundamental parts of our criminal justice system." End of quote. And it goes on again. "The right of a citizen to institute a prosecution for a breach of the law has been called, quote, a valuable constitutional safeguard against inertia or partiality on the part of authority." And so we have, for example, the Canadian courts acknowledging that the right to lay a private complaint, okay, without being stopped, as it were, by a DPP, is a significant right, is a valuable constitutional safeguard against partiality on the part of authority. And this was the concern here. This is the concern here, that the DPP that we currently have has shown himself not to be politically independent, and that the concern that persons who may be bringing criminal matters against politicians or against politicians of the day may be stopped by this DPP, and therefore their right to not have to face the partiality of a DPP is infringed upon. And this we must remind you of here at the Thusian Institute for Religious Liberty. Furthermore, when we look at the Representation of the People Act, when we look at what they are seeking to do with that act, because that was one of the things that was being protested as well, we see that in the RPA section 51, subsections 3 and 4, the act of speaking false statements against a candidate or prospective candidate during or at an election, okay, false statements against the conduct or character of such a candidate, it is described in the Representation of the People Act as an illegal practice. And if a person, if someone is found guilty of it, they are fined $750, they are made to spend a certain period in prison, 1 year, and also they would have to vacate their seat in the House of Parliament if they are found guilty. This area, this offense, as well as the penalty, the stiff penalty of having to vacate your seat if you're a minister or if you're in the Parliament, this is being removed or seeking to be removed by the bill to repeal those sections, according to the bill that was brought to Parliament, a bill to repeal sections 51, subsections 3 and 4 of the Representation of the People Act. And there's been a lot of argument about whether or not it's a bad thing. We've heard the opposite side, that is the government, they're the ones who are being protested, saying that it's not a bad thing. But I want to point for the next 10 minutes or so to some evidence concerning a similar thing that happened in England. I want to refer to the Wallace case, a case also that Ms. Kay Bacchus-Brown spoke about in her response. In the case of Wallace 2010, in England, we had a situation where a similar law exists, and under that law, a parliamentarian by the name of Phil Wallace was ejected from the parliament because of lies he made in the elections against an opponent. And I want to refer to an article called Phil Wallace Ejected from Parliament Over Election Slurs. And mind you, this was 2010. This is just the other day that this law is operating in England, okay? And we see where parliamentarians are suffering the fate of being removed from Parliament for the same things. But here we have our government trying to remove this section of the law to make it no longer law so that parliamentarians here cannot suffer the same fate if they are found guilty of the same offense. But consider what happened in England in this matter. We have here, I'm going to read some portions of it for you. It says, referring to Mr. Phil Wallace, he's said to have had leaflets where he claimed that his opponent was trying to encourage the existence of Muslim extremists in the country through immigration. And these were seen, the High Court ruled that he knowingly made false statements against his opponents during the elections. And what was the result of that? We are told here, in this decision, Wallace automatically loses his seat in the Commons and is barred for 3 years. So according to the law in England, if you're found to be making false statements against your political opponent during an elections, you can lose your seat and you could be barred from being in the Parliament for 3 years. Let me read some portions of it. It says here, the case was brought under Section 106 of the Representation of the People Act 1983, which makes it an offence for anyone to publish any false statement of fact in relation to the candidate's personal character or conduct to prevent them being elected, unless he can show that he had reasonable grounds for believing and did believe that statement to be true. So the law in England is essentially the same as here. If you make a false statement against a person's character or conduct during an election, it is an offence. We are told further, and I quote, the court ruled that Wallace's claim in mocked-up newspapers that Watkins, his opponent, had wooed Islamic extremists and failed to condemn radical groups' attacks. They claimed that it was deliberately and knowingly misleading. The court ruled that his statements against his opponent was deliberately and knowingly misleading. Wallace was also ordered to pay all costs. Watkins said, his opponent said, and I quote, if you know you have lied about your opponent, then simply you have no part to play in democracy. End of quote. It goes on to tell us, Labour leader Ed Miliband told Channel 4 News, and I quote, the court has made a very clear judgment in this case, a clear finding of fact about what happened and what Phil Wallace did, in that he knowingly made false statements about his opponent. Therefore, I think we have taken the right decision, and the right decision is to suspend him from the party and to say we are not going to fund his further legal action. I think reasonable people will think we have done the right thing. I think that most members of parliament, the vast majority of people, fight very clean fights, and I think most people would agree that that is the case. There is obviously rough and tumble in politics, but sometimes you go beyond rough and tumble. I think this is a salutary reminder to all politicians across the political spectrum about the importance of a clean fight. It certainly is a reminder that I think all of us will take to heart. So even his own Labour Party, Mr. Phil Wallace, said we are no longer going to support his legal fight. The court has ruled against him, and it shows that we all have to be careful during elections. Yes, there's going to be rough and tumble in the politics, but we must not lie. We must not go beyond the rough and tumble. We must have a clean fight. Now, understand the importance of this decision that was taken in England against Mr. Wallace. They are saying in a democracy, you shouldn't be lying about your opponent. And if that's how you're going to try to get into the parliament, by telling lies about your opponent, then you're going to have to face the penalties of the law. Here, we are getting the impression that the government ministers do not want to face the possibility of the penalties of the law, because instead of going to court and allowing the cases to go through as were filed against them, they are instead bringing a bill to repeal or remove those sections of the same said law, the same set sections under which they were charged. There are one or two other quotations that I would like to refer to as we are coming down to the end, and I'm referring to the document from Ms. Kebakers Brown, the lawyer, when she identified other cases. There was the case of Grell of 2007 and Cummings 2010. And she says here, in those three English cases, elected parliamentarians lost their seats when they were charged under Section 106 of the English RPA. That's what I was referring to. All three parliamentarians were charged for making false statements in fact for the purpose of affecting the return of their opponent candidates. In Grell and Cummings, listen to the kind of nasty things that were said in those two cases. In Grell and Cummings, the parliamentarians published words to the effect that their opponent was a pedophile, homosexual, had sex with 14-year-old girls. In St. Vincent, the four ULP parliamentarians were charged for making false statements in fact for the purpose of affecting the return of their opponent candidates. The words they published were pedophile, had sex with 13-year-old girls, lesbian, and she went away a girl and came back a boy. The evidence is on tape and is uncontroverted. So these are the things that the claims that were made by the opposition members, these are the things that they're saying was said about them. These are not nice things, my dear people. This is not just a matter of you say something light that you consider light. These are things that taint the reputation of people and that could seriously cause them harm. And I believe this is why the law made it such a strict penalty, that if you were guilty of such things, you should not sit in the parliament. And then we are told of these kind of allegations. It was said, for example, it is said here that the effect of false allegations of fact concerning a candidate, such as a pedophile or homosexual, child molester, lesbian, it is clear that these things cannot be said. Because when you say these things, you are harming the person, you are harming their possibility of being a candidate, because people, especially in societies like ours, which have certain consciousness, they don't want to know that they're voting for persons who are of certain descriptions. And when you lie to them and you convince them to vote against a candidate because of the lies you told, you do not deserve to sit in the parliament. And so when people protest against this bill and say it should not pass, it's not a light matter, my dear people. It's not a light matter at all. We are told here that the law lords in Cummings had this to say: to call anybody a pedophile, let alone a person in the eye of the public, such as a member of parliament, is a grave and serious allegation as can be made. End of quote. So you see, these things are serious, and this is why in these cases, these parliamentarians in England were removed from their seats. Today we have a similar situation, but we have an effort being made by the government not to have these parliamentarians removed, not to have the matters go through, because that would be the effect, if you repeal the sections of the law. Who judge will try the matter knowing that the section under which you complain is no longer law? So essentially, the matters would be quashed. My dear people, we are saying in this program that the right to a truly free vote, by having access to truthful information and not being swayed by lies being told by opponents in an election, is being interfered with here. And the democracy is therefore being undermined, because fairness and fair competition is being attacked here in an election. And this ought not to be. And no government is to pass laws to protect itself selfishly against the freedoms of the people. So here it's where we're coming to an end of our program. And I remind you that you may contact the Thusian Institute for Religious Liberty by calling us at 528-1015 or 432-5268. You may also send us an email at tirlsvg@firstfreedomthink.com. And until our next program, we thank you for listening and we wish you a rights and freedoms friendly week. And we ask you please to continue to stand against any kind of legislation that attacks the rights and freedoms of the people and certainly the freedom of expression. May God bless you. Bye-bye.
Everybody wants freedom. Everybody wants freedom. Freedom of thought. Freedom to talk. Everybody wants freedom. Everybody wants freedom. Freedom of speech. Freedom to teach.